Hi, everyone. Welcome to the Michigan Law School Insights from the Quad series. My name is Monica Hakimi, and I'm on the faculty and one of the associate deans here at the law school. We decided to launch this series because of COVID. We know that many people are isolated as a result of the pandemic, and they're isolated precisely at a time when they're thirsty for serious conversations about the challenges that this country confronts. So this is an effort to do what I think we do really well at Michigan: build a community, a virtual community, but still a community, to engage together on some of the most important issues of the day. I'm delighted that so many of you have joined us this evening. We have a mix of alumni, current students, faculty, staff, and other friends of the law school on the call. Welcome to all of you. And I'm absolutely thrilled that to kick off our series, Catharine MacKinnon will speak about her recent proposal, co-authored with Professor Kimberlé Crenshaw of Columbia and UCLA law schools, for moving this country closer to equality. Professor MacKinnon really needs no introduction. She is the Elizabeth A. Long Professor of Law here at Michigan and the long-term James Barr Ames Visiting Professor of Law at Harvard Law School. She specializes in sex equality issues under international and domestic law. She has pioneered the legal claim for sexual harassment and has had a profound impact on the way we think about equality, not only in US law, but also in other domestic and international jurisdictions. We've decided to structure today's event like a conversation, with me asking Professor MacKinnon a series of questions about her recent proposal. Thanks to those of you who submitted questions in advance. And for those of you who are still itching to ask something, please do so via the question and answer session on the Zoom. I can't promise that we'll get to all of your questions, but we're certainly interested in knowing what they are, and we'll definitely try. So to start, Professor MacKinnon, thank you for being here. And why don't you just go ahead and describe the proposal that you and Professor Crenshaw have advanced and explain some of the problems that it's aimed to address?
Okay, thank you, Monica, and thanks for asking me to do this. And hello to everyone. And in particular, I send love to all my former students. I love you, I miss you. I am so proud of your place in the world and everything that you do. Our proposal is both an act of hope and frustration. It's the idea, it's called the Equality Amendment or an Equality Amendment, with a little humility in it. And we proposed it because well, women were not even mentioned in the Constitution originally. This is an amendment to the US Constitution we proposed. And once you see how people of color were mentioned in it, maybe it's kind of good that women weren't mentioned at all. In other words, there was a founding subordination of all people of color and actually of race as a category, together with an exclusion of sex and of all women, including women of color, from the Constitution. So, and this, in our view, has been continually reinscribed ever since through a variety of means, principally despite real attempts at amending the Constitution. For example, with the Equal Protection Clause, the 14th Amendment with its Equal Protection Clause, added after the Civil War, but essentially with spit and a prayer, you know, an attempt to produce further equality, and with the Congress of the United States attempting to implement that amendment. There's been courageous, progressive initiatives advanced to address those same inequalities, but actually, at certain times, although there have been reasonably transformative moves advanced throughout that, including through the civil rights movement initiated by African Americans in an attempt to get social equality through legal equality, through those particular moves, and also some by the women's movement and movements of other peoples of color, notably actually Asian Americans whose initiatives, litigation under the Equal Protection Clause have been very strong in advancing some transformation in it. And despite all of this, a lot of the legal developments have seriously undermined those initiatives. And at times it seems the law and the courts have been going further backwards than forwards. Indeed, they have. And given all those doctrinal developments, which we can talk about specifically, but certainly include the intent requirement, which applies both to sex and to race under the Equal Protection Clause, which has been particularly destructive, particularly where systemic discrimination requires no intention. Mm-hmm. So if you are required to prove intent, it's precisely when discrimination is most systemic that the least can be done about it through law. And also affects the sex and race the same, but there are other doctrines that affect sex and race differently. For example, race is regarded as a suspect classification under the Equal Protection Clause, which ends up meaning that, for example, affirmative action, even when you're able to have it, is harder to justify for race than for sex, because the category, get it, is suspect. Whereas sex then remains marooned in sort of middle tier scrutiny, with sex discrimination law, well, sex discrimination infrequently being found for women because often sex is thought kind of a nice differencey thing, so far as women are concerned, whereas fairly frequently it's found with regard to men, whereas their sex is not seen as some nice differency thing when it is used to disadvantage them. Thus, we build a sex equality law around the status of men, which, as the advantaged group on the basis of sex, even when disadvantaged in particular cases, is not, has not positively, moved the needle forward for women in the ways that it should. So these are just two doctrinal ways that sex inequality has been continuously reinscribed through the main headings of doctrine under existing law. And so our idea, actually my original idea is, look, if you're going to have something called an Equal Rights Amendment, this is like 10 years ago or more than that, it's seeming to me, and this is the United States after all. If you're going to call a thing Equal Rights Amendment, it ought to have race in it. Really, it ought to. It's not going to do what it calls itself. It's not going to deliver on a promise of being an equal rights amendment if it doesn't have race in it, as I say, given the United States and also given the status of women of color and the way in which discrimination based on race gets used to undermine women of color's status as women, actually, both legally and socially. So a lot of us have thought that was important for a really long time. And so I've been involved with various equal rights amendments all along, continue to be in favor of them. We can give some of the history of how this proposal actually came to be. But its main ideas are to be substantive as opposed to abstract. That is, substantive equality, not just formal, and to be affirmative and intersectional rather than negative and categorically discrete. And so its various provisions aim to do that, which we can talk about in more specificity as we go ahead.
And why don't we? Why don't we spell out a little bit more the content of the amendment and what the various provisions would do?
Okay, so the content is Section 1 says women in all their diversity shall have equal rights in the United States and in every place subject to its jurisdiction. So this is substantive like, say, CEDAW, which the Convention on the Elimination of All Forms of Discrimination Against Women, the United States, along with about 2 other countries in the world, has not ratified, which uses the word women. By this is what we mean substantive. And in so doing, our argument is that it is intrinsically anti-hierarchical rather than categorically prohibitive. This is section 1. So it is substantive. It is also intersectional in that women, in all their diversity, includes all women with everything that makes women be who women actually are, which is necessarily race, ethnicity, religion, disability, age, sexuality, gender identity, everything that is part of the making of the group women, together with sex, sexuality, and gender, is expressly recognized. So it is substantive and intersectional. And one can't say, oh, that's happened to her because of her race. If she's a woman, she's still a woman, see? So this isn't section 1 isn't race-based, sex-based, it's women, the group, anyone who's in there. It is also affirmative in that it says women in all their diversity, or I should say women in all our diversity, shall have equal rights. Shall, so far at least in law, is recognized as being mandatory, even though the Supreme Court has at times decided that there's mandatory and mandatory, but anyway, and some of it is less mandatory than others,
right?
In Orwellian logic, but never mind. This is a new amendment, and so we shall have equal rights here. And it's also horizontal in that it does not require state action. Do notice. So section 2 is an upgrade on the 72 ERA. It says equality of rights shall not be denied or abridged by the United States or by any state on account of sex, which is the 1972 ERA. So whether that has passed or been recognized as passed or not, which I'm also working on to get it recognized as having been passed because enough states have now ratified it. What this provision then does is say sex and then defines it as including pregnancy, gender, sexual orientation, or gender identity. So one of the moves here is to say that all of those are included in sex, which we did before the Supreme Court did it, but they recently have. They haven't done it for pregnancy yet, actually. They've done it with gender, sexual orientation, and gender identity, which some of us thought was pretty astounding. But anyway, we read what they read. The term sex includes those things. And then it says and or race. So the and or is, although it may seem a little awkward, is our best attempt to allow the classifications to be fully separate when they are separate and together when they are together, that is in life, so that law will track life. So sex and or race means race is already then added to ERA separately and entirely as a category. So a whole new jurisprudence of race is invited here. But at the same time, intersectionality is built into it so that anytime you have an and often, say, with men of color, it's intersectional for them as well. It's based on race, but actually it's because they are men of color that they are being discriminated against. Lynching, for instance. This happens, like, still. And so often there's an unrecognized intersectionality in the discrimination against men of color. So then we say, after race, that it includes ethnicity, national origin, or color. So what we're doing there is racing those classifications by saying, actually, those are raced in this country.
Mm-hmm.
And they need to be recognized in their prohibition as contributing to the strength of the classification race, even as they have their own specific groundings.
Mm-hmm.
So that's what we say. And then we add, and or like grounds of subordination, such as disability or faith. Now, this we can talk later about having given rise to various controversies. Disability doesn't seem to give rise to much as a major ground of structural subordination in the United States. The disadvantages that are recognized as attached to it have been prohibited under certain statutes to some effect, but it's not in the Constitution and needs to be. And we're saying it is a like ground of subordination and can be separate or can also be combined. Mm-hmm. For example, the very high rates of sexual abuse of disabled women is a intersectional recognition here. And faith, we added because of the particular subordination of people of non-dominant faith groups in the United States. Mm-hmm. And here, we can talk later, I guess, about pushback on the ordinance, or on rather the amendment, because that's basically the only place we've gotten pushback. But by some people who think faith should be taken out of it because they think it will be misused by dominant religions. And actually, the way this is structured, dominant religions can't be subordinated, except possibly in extremely exceptional circumstances, in which case it should be recognized. Mm-hmm. But overwhelmingly, dominant religions are dominant.
Right.
And religions that are subordinated on the basis of religion. I mean, anybody who can read Title VII law will see what happens, say, to people of the Islamic faith, Muslims, after 9/11. Mm-hmm. And also some of it under the Equal Protection Clause, and some of it, in my opinion, is disgraceful law, including especially the constitutional cases. In the way intent is used, all of that, it's like, okay, so needs to end. And so this would do that. And then we say, no law or its interpretation shall give force to common law disadvantages that exist on grounds enumerated in this amendment. So what that means is the way, say, race is built in and has been previously built into various common law adjudications. What this does is say, for those of you who know Shelley and Kramer, which is a pretty well-known case, it says that, but it's been limited to its facts. Mm-hmm. It says that that is raised to a constitutional level principle across the board to all categories. Mm-hmm. So that if you use one of these classifications as embedded in common law, that has to go as well. It just being explicit about that. The third provision is an implementation provision that requires that the rights be fully realized by Congress and the states. That is, that they have to take legislative and other measures to prevent or redress disadvantage suffered by individuals or groups because of past and or present inequality as prohibited here. Mm-hmm. So, that gets us to, you've got to do it, a further recognition express of disadvantage, which current equal protection law has excluded from recognition, which is why we need a new amendment, among the many reasons. And also it's customary to speak of past discrimination as if it's all way back in the bad old days, when actually it's very present. And so we say past and or present. And then we say, and shall take all steps requisite and effective. We said requisite and effective instead of necessary and proper, which is existing language, and we like requisite and effective much better. To abolish prior laws, policies, and constitutional provisions that impede equal political representation. What this is about is that equality needs to keep on being implemented. And that can only happen if the voting and electoral structure actually provides for equality, as it today does not do. So this doesn't say how that is to be changed. For example, the Electoral College, which I think this has squarely in its sights, doesn't say at all how that will be changed, but it does say it has to be, because equality is not what it provides for, as I think well known. And actually, the Electoral College was created as a compromise in light of the recognition of the existence of slavery at the time. And it's racist to the core. And so, you know, there's a history behind that can be brought to bear in whatever litigation would be inevitable in that connection. The fourth section says simply nothing in section 2, which is negative equality, that is, government shall not infringe upon, which requires the actual existence of a law that does, right? So it says nothing in section 2 shall invalidate a law, program, or activity that is protected or required under section 1 or 3. So that means if we have legislation under section 3 or litigation under section 1 that actually that ends discrimination against these various groups, we cannot do what we do now, which is, oh, people who were privileged by that discrimination are now being disadvantaged by either a law or a piece of litigation that is going after ending the discrimination. So we're saying if something is required under 1 or 3, under 4, it is not allowed to disallow that. The simple idea is that undoing discrimination is not discrimination, as formal equality tends to think, and as categorical approaches to equality thinks. And in other words, promoting inequality undoes inequality. If you're actually promoting equality, you're undoing inequality. You're not enforcing it. Substantively speaking, even if abstractly it may be seen that you are, which is why this whole thing is substantive in the first place rather than abstract. So those are the 4 provisions and how they work.
Okay, that's great. Thank you so much. And so I hear you saying that, you know, what you want, the reason you want to have this done as a constitutional amendment is that you want to override a number of the constitutional and statutory doctrines that have developed to entrench various forms of inequality. And I guess so one follow-up question would be, what would keep courts from applying those same doctrinal tricks to undercut your amendment if passed in ways that have vitiated prior constitutional attempts to secure equality?
Yeah, and you know, that's a really good question, and certainly does arise in people's minds, having seen these maneuvers undercutting what was the clear intent of the Equal Protection Clause at the time it was entrenched, and also of the Reconstruction Amendments at the time that they were passed. What our view is that there's a very basic constitutional doctrine, which is if you have a more recent amendment that you are litigating under or invoking, that the whole point of having a new amendment is to supersede prior amendments. In other words, it wouldn't be needed if all the same old approaches worked. So by definition, because it is a new amendment, it can't use the same old ideas. So, it may be that there's ways of coming up with yet other ways of squaring the circle, of making sure that this can't work. It's just that we've had, a good 100 and how many, 50 years now of experience with overt attempts to make sure that equal protection did not mean actual equality for the people who've needed it the most.
Right.
And those have been ingenious and appeared, oh, so neutral on their face, as if they don't have, as if they didn't exist to entrench white rights and men's rights, which in any event, whatever their intention, that is what they have done. Mm-hmm. And we're most interested in those outcomes. And so having that experience, this is built on countering that experience and figuring out where it comes from. For example, Aristotle, it comes mm-hmm. from formal equality. That's like old. Mm-hmm. And he didn't think slavery was a violation of equality. The idea that women couldn't be citizens wasn't a violation of his likes alike, unlikes unalike treatment. He already had equal people within his polis, and his whole idea of equality was to keep those guys from fighting with each other. Mm-hmm. So that's why he said likes alike, unlikes unalike. And that doesn't work in a society with entrenched structural inequalities previously built in. Indeed, Aristotle didn't even intend it to be used in such contexts. He intended it to be used after you already had a society in which a narrow elite was ruling. Mm-hmm. And the people they ruled it wasn't even a question as to whether that was an unequal structure. So I think, once we figured out all that and the built-in disadvantages calling for an entirely different approach than this so-called common sense equal sign notion of equality. In other words, you first have to be the same in order to be treated the same. Well, okay, diversity is already a completely different idea. It means that differences among people are affirmatively valued and people are treated the same based on their differences from each other. In other words, equally hired, equally admitted to higher education, equally recognized as capable of everything in the society. And, so the whole idea of diversity is itself the most anti-Aristotelian idea around. Mm-hmm. So long as you don't build in diversity from white privilege, diversity from male dominance. Mm-hmm. If you build that in, then you're just starting over again, re-entrenching the same hierarchies within it. Mm-hmm. But if the recognition is to undo the hierarchies and to value everyone's uniqueness and the contributions that all communities bring, and the members of all those communities bring forward from their experience, then you have something more like what we're talking about. And, that foundation doesn't allow for the pre-existing, roots around, over, under, around the equality requirements that we've seen in the past.
Mm-hmm, mm-hmm. That's great. And so, in addition to that, so when I think about some of the proposal's strong points, just in my own mind, they include, first of all, the recognition of intersectionality. Second of all, the requirement, the lack of a requirement that there be state action. So the effort to remedy inequalities in relationships that are not structured around the state. And third of all, not just the obligation not to intrude or cause inequalities, but also affirmative obligations to take steps to promote equality. So those are some in my view, really strong points. I'm wondering what I'm missing. So what else you think are among the proposal's really strong points? And then if you could also identify what you think some of the most salient criticisms one might lodge against the proposal would be.
Yeah, we like those that you like very much. And the two pillars of it, really, substantivity and intersectionality, are conceptually fundamental. And the idea being to transform sex and race both concretely, as lived, through and in law, through law and as lived. The idea is to, undo white male supremacy, basically. The structure that we're in. And, so we see those goals, but as its strongest points, as being its, core commitments and centrally built into it. Now, I don't guess. Well, okay. So there's also the categories that are not mentioned, but which are permitted. That is to say, when we say including or like grounds of subordination, such as disability or faith, that is an expansion joint. And I think that's also a strong point that deserves being thought about. That is categories that we may not even know about now, but will become more vivid as time goes on, more clear as more equality comes to be on the grounds that we do know. The other thing is there are grounds that we know about now that we haven't mentioned that are not prohibited under existing law, of which the primary one in my mind is class, economic class. And that would need to be fully developed in terms of being structural, which in my opinion it is without question. But in litigation could be a unnamed but analogous ground. So that I would say would be another strong point, and maybe it's a weak point that it isn't mentioned. One could say that as a criticism of it. But I think the main criticism of it is that it's a law. And it's a constitutional amendment. So there's the question of the constitutional amending project, not only the difficulties of achieving it politically, which requires a lot of states and would have to go through those states. We actually think that isn't maybe all that hard right now, but maybe we're underestimating that. And some of the groups that are most interested in this as something to forward, because it embodies the society they want to live in, think that they could get it through the states. Of course, it has to go through the Congress as first as well. So that may be a drawback, but I would think would just be seen as a difficulty. But anyway, that's as a process question. But that is a law. I just want to stress a little bit more, which is we don't think that you get equality just because it says so in law. What our take is that, first of all, one of the ways you get equality is by fighting for it, including in law, but that's a much broader political process. And so this is intended to be a partial focal point for a broader social conversation, that the process of which having is helpful in moving toward the equality goal, at least as much as actually having the law. Another way of saying it is you get what you fight for. And that means you got to fight for it first, and in order to have it. And so that there is no necessary magic in it being in law. At the same time, it's hard to imagine having the kind of equality that we are proposing, which is real, which is the undoing of hierarchies, without law. So it isn't that the law is a sufficient condition for getting that equality, but it may be one of the necessary ones. So that's our idea. That is, equality, we think, is unlikely to be produced without law. But that the process of a democratic political engagement that is necessary to produce an amendment like this one is a lot what creates the preconditions for the equality to be real once it exists as a constitutional amendment. And then, of course, there's the obvious legitimacy that the existence of such a thing in the Constitution gives that we are currently deprived of. As I said, women aren't even mentioned in the Constitution, and the mentioning of people of color is denigrating in the extreme. And so both of those would be shifted substantially in terms of legitimacy. The other, I guess, critique that as I mentioned before, that's been leveled is included the inclusion of faith in section 2. I am not movable in this question, but it's not up to me, entirely. But my view is that, as I alluded to previously, so there are a lot of people who are litigating constantly these days against people asserting religious claims. And there are a lot of religious rights already in the Constitution and in statutory law, both under Title VII and the RFRA. RFRA, the Religious Freedom Restoration Act, and those are being used against equality rights. And so what that suggests to the people who are on the equality side and entrenched in litigation against religion is that they don't want to give even a little tiny bit more possibility to that side. And my view on that is, number one, sometimes first of all, we are everybody. And if you're going to give rights, the kinds of rights that we all need, it's possible that some people whose side you may not be on will get those rights. And I'm actually kind of for that. I mean, I'm actually a lot for that. I don't need people to be on my side to have rights. Everybody ought to have them, is my opinion. And then if we have conflicts, and you can't entirely eliminate conflicts of rights in a document like this, then you fight those out, you litigate those out. But it's a much more, it's a more square, more fair, more level playing field for once. In other words, the idea here is this gives us a fighting chance against, say, religious requirements that are anti-sex equality, because those two would then be equally posed against each other, or even not so equally, because most of them, just to get a little finger pointy here, are in the name of the Christian religion, which is not a subordinated religion. So whether they could even bring that under this is something they would have to first win in order to have even, quite frankly, a level playing field against sex equality, which is here, is recognized here, given that it is overwhelmingly women and women's sex equality rights, such as being pregnant while teaching in religious schools, for example, which is now being fought over under Title VII and in connection with RFRA also, and has yet to be fully resolved, and is not decisively yet resolved. And so the possibility that this might create yet another forum in which that could be raised is not something that I think is worth eliminating the spiritual and conscientious faith-based rights that a lot of people are affirmatively discriminated against in the subordination sense of the term. People are subordinated because of their faith. And that includes Jews, for example. And there are rights that exist that can yet still be asserted already, but some of us don't think they're enough. Anti-Semitism is alive and well, and being, in many respects, documented as stronger every day. And, for reasons like that and others that I previously mentioned, I think we need this in there. So, that's both saying something that I think some people think is a weak point that I'm defending as defensible, and to me, one of its stronger provisions. But that isn't to say that there's no opposition to it there.
That makes sense. So maybe we could shift gears a little bit, and I could just ask you about the writing process. So this is a joint proposal that you and Professor Crenshaw developed together, and you each have a substantial body of work on your own terms. And so I was just wondering if you could talk a little bit about how you would describe each of your most distinctive contributions to this particular proposal and to the article in developing it.
Yeah. Kim and I have worked together a lot for decades, many decades, including ever since, especially she established the African American Policy Forum at her request. I've participated in any number of events there, but also she and I just have worked together all for decades, literally. And her work has always actually been substantive, not abstract, in the sense of being animated by a concrete analysis of structural hierarchy, the dynamics of real political and social power. That's always been there in her work. But she hasn't theorized that. She's just done it, okay? And similarly, my work has always been intersectional. And, in the sense of embodying an understanding that race in particular is part of sex, or sex is incomplete. And you can find that all the way back to 1979, my book. It's got a whole section under women, subset black, pages, ... Black, subset, capital B, by the way, 79. Subset women, ... C also, etc. And, but without, again, I didn't theorize intersectionality, Kim did, so once she theorized it so brilliantly, it's become possible to, once she pioneered the theorizing of it in such brilliant ways, starting from 1989, it's become possible to do so much more with it. So those are, the two pillars of the piece and what we contributed to it. A kind of major discovery for me in all this, although, as I say, we've always worked together and it's always worked, is that we don't disagree about a single thing.
Mm.
You know, I don't go into things assuming I agree with anybody, you know.
Right.
It's just we wanted to do this together, so we actually in the process, the way this happened was as a celebration of the combination of 100 years of women's suffrage with the first year that all 18 top law school EICs were women.
Mm-hmm.
Somebody noticed this, someone at Duke, and proposed there be a combined something that celebrated women's suffrage by all of the law reviews. So Yale wanted me, and obviously Columbia and UCLA wanted Kim, and Michigan brilliantly chose Denise Brogan-Cater, a graduate of our school, as their contribution, and as Michigan's contribution. Harvard, it seems, chose no one. I've been able to figure that one out. And although their EIC participated very actively in the volume. Anyway, there's a volume. And we were told, write whatever you want. And said some things about how you can write about your own life and stuff. I don't want to write about my own life. I want to write about women's life and what we need yet if we're going to publish something out here. So Kim and I decided we would do that together. And there was a little bit of pushback on, you know, together, really? And I'm like, you know. So anyway, that's how we came to write this article. But to back up a little, we came to write this thing together, the amendment, because I was originally working on it with Charles Ogletree at Harvard. And Tree was about to, with Kim and all the other people acknowledged in it, that is Mari Matsuda, Chuck Lawrence, Terry O'Neill was the president of NOW at the time, Gloria Steinem, who's been for this and behind it strongly ever since we thought, you know, this thing needs race in it and all this. Anyway, we were all ready to go forward. And then Professor Ogletree became ill. And at around about the same time, we were thinking of having a meeting at Harvard Law School with bringing everybody together to workshop the thing. And Harvard decided they weren't going to pay for lunch. So I said to Kim, hey, how about we do this at the Center on Intersectionality and Policy Studies at Columbia? And the African American Policy Forum sponsored the thing. She said, great. She invited us all, paid for lunch, and everybody went to New York. And actually, it turned out to be easier for at least a lot of the New York-based people who were able to attend. And they are all acknowledged in the beginning of the piece. And so we workshopped it in a time that turned out to be a couple weeks after the 2016 election for president. And then we workshopped it again much later. And so all those contributions, together with Kim's and mine, became the product that then Kim and I wrote the article discussing what all our thoughts around it were. And Kim is amazing with, not only brilliant, but amazing with technology. So once we met together and she stuck the whole thing up, put our draft up on a thing on the wall so we could see it all. And then she would go through and say, you know, sort of think this, and maybe let's get this so it really does it. And then we got it so it really did it. And then we thought, you know, that's going to scare everybody to death. So let's back it off a little bit. That was her kind of contribution. I kind of never made that contribution, but was able always to come up with a way to back off with the thought that Kim had. So I'd like write it down on paper, and then we'd stick it up. She'd put it up there. And so we revised the whole thing a bunch of times. And, you know, then my amazing Harvard students, where I was at the time, did a site check and were able to, you know, help with the footnotes. And so we were able to do the kinds of things you want to do with footnotes, which is both substantiate what you have to say, but also at times note you know, a lot of people don't agree with this, and this is their thing, and put that there as well. So anyway, that's how the process came. But it kind of began to strike me after we've been talking sometimes for hours that we don't disagree on anything.
Yeah.
And not even strategically, which is often the hardest.
Right.
But certainly not in substance or content or history or anything. That to me was kind of incredible. It would have been fine if you know, we had disagreements and we built them in and worked them, you know, said things around them that, you know, presented them both, or however we did it. That would have been just fine. But it turned out not to be necessary. So anyway,
well, that's
the
very
process.
Cool. I have not had that experience of not disagreeing with anyone. So I look forward to that opportunity for myself. Yeah. And I think we have time for one more question. And this is a question that comes from a current student, and I think probably reflects what a lot of current students want to ask, which is, okay, so seeing as this amendment is not yet in force, how can members of the legal profession take tangible action to promote equality when the system as it currently stands is so, in their view, fundamentally inequitable?
Yeah, now our thought has been that this piece and the principles articulated in this amendment could be seen as a guide to, first of all, interpreting the existing proposed Equal Rights Amendment, which, although it most probably requires state action, although that hasn't yet been decided, that if we pass that, we could use this as an interpretive tool and build in an anti-hierarchical approach, at least to sex, which, as Ogletree once put it to me, you know, even if we don't get race added, I just want to be clear to you that we are for the ERA. That gets most of our people. You know, so we would then want to build in an approach to sex that necessarily was intersectional, even though it doesn't expressly notice it on the face of the text. You can do that by interpretation. So, you know, that would be an idea. And also potentially with the Equal Protection Clause, although it's more difficult, given everything, you know, that it has been done with it and that is recognized here. But also, so far as political activism goes, as well as policy. Policy development can be predicated on this, implementing a whole range of existing provisions, including state ERAs, which a lot of states have, as well as legislation, federal legislation and state legislation, state human rights provisions could be used for. It's also usable in terms of principles under international law. And that's possible in the international legal system, but also to more effectively utilize international human rights principles in the domestic legal system, which it is in serious need of. And then, as I say, for political activism. A lot of it recognizes that, for example, the inadequacies of the political activism around women's suffrage, the actually racist ways, white supremacist racist ways, that the women's suffrage movement at times developed, and its exclusion of African American women who were passionate in its favor and wanted to vote, and whose support was ultimately extremely powerful in advancing the cause. But that, you know, that racism in that movement set back advancement for women in serious ways. It's a lesson. And there's a lesson in the contemporary women's movement also, where women of color have always been its leaders. They have always been in its leadership. But the mass media doesn't seem to think they even exist. And that's a lie. And it needs to be combated. And also then those images get superimposed on reality to where everybody begins to think this is some white woman's thing, when it never has been. And it's an exclusion of the contributions of women of color throughout in building that movement that sees it in that way. So, and then that contributes to their further exclusion, which isn't to say that white women in the women's movement don't need constant checks on racism. And in fact, white privilege, that of course needs to happen. We're not acting like that isn't there. I'm just saying that women of color are there, always have been there, and still very much are. So the combination of sex and race as a way of forwarding political activism, this, which younger people understand quite well, in fact, very well, is another way that, this work of ours can contribute to that work of theirs.
Great.
I just want to add one thing to it, and that is there's a real reason why we started off here, this piece, recognizing the contribution of Native peoples to constitutional thinking. There's a big historical debate about it, and whether the Iroquois Confederacy was fundamental, as Benjamin Franklin said it was, to the construction of the U.S. Constitution. People who rely on written records say there's no indication of that. Well, wampum is a written record, I should point out, but also not everybody can read it, and there's lots of different ways of creating history. And Native peoples who were subjected to genocide and today to cultural forms of it contributed substantially to the Constitution, but two things were left out from the Iroquois Confederacy's rules. One, women's equality, which they had, and two, the vision of needing to look at far generations, the sort of long distance vision view, which is why our piece begins unto the seventh generation.
That's great. Well, thank you so much for this wonderful conversation, Catherine. It's been really nice seeing you, and I hope you in the audience will join me virtually in thanking Catherine. I will do the clapping on behalf of all of us. Thank you so much for being here. And to all of you in the audience, I hope you'll join me for future events in this series. The next one, just to mark your calendar, is scheduled for September 29th at 5 p.m. and it will cover the legal responses to the COVID-19 pandemic. Our speakers will be Professors Nick Bagley, Kyle Logue, and Nicholson Price. So I hope to see you then. And again, Catherine, thank you so much for being here. It's been really wonderful talking to you this evening.
It's been wonderful. Thank you for your questions, and to the audience for your contributions and for being here. I miss seeing you, and I hope at some time in the not too far future we'll be able to have our paths cross in person.
I really hope so too. Thank you.
Thank you.